Welcome to Cut to the Chase, where we talk about compelling legal, regulatory, and public interest information and news. Your host is Greg Goldfarb, an attorney, entrepreneur, investor, and activist.
All right, time for our favorite podcast, Cut to the Chase. Double breaking news. It's like a double reverse breaking news and the Boy Scouts settlement case that's up on appeal and sort of related to the Sackler settlement with the non-consensual releases. But it was like double breaking news. First, Justice Alito temporarily stayed the settlement in the Boy Scouts sexual abuse mass tort, and then it was dissolved. So I've brought on Jason Joy, third generation trial lawyer in Houston, Jason Joy and Associates. Before that, he Army 75th Regiment, Ranger Regiment, Special Ops. Where did you go, Jason? Okay, there was like a bolt of lightning that came down. But Jason, how are you doing? All right?
Pretty good, brother.
All right. So I want you to explain what is going on, how we got here in the Boy Scouts. I mean, the Boy Scouts, we're talking about a group that was started in 1910, youth organization shaped lives of millions. And all of a sudden we find out that there's been sexual abuse rampant for decades leading up to this litigation. So we got statute of limitations, we have non-consensual releases, all this stuff to talk about leading up to the stay, where we're at, what happens if the whole thing gets reversed. Let's let her rip. Jason, explain.
Yeah, a lot of time back there.
Some background.
So, as you mentioned, Boy Scouts, all-American institution there. It goes back to Teddy Roosevelt, been over a century. I believe it was act by Congress that created it, but it's no secret that over the last century or more, and it's not just Boy Scouts, it's Catholic Church, any church organization, schools. Pedophilia, unfortunately, was rampant in certain places and at certain times, and Boy Scouts was not immune from that. And in fact, the Boy Scouts national organization was well aware of that. We've learned through litigation in recent years that they kept what was called the perversion files, where, as early as literally the 1920s, they were keeping lists of people that were known or suspected to be credibly accused of being pedophiles. And so they kept a database that, from what I understand now, is near 20,000 names, although I'm sure it's gone up substantially since the bankruptcy was filed in 2020. But to your point, the Boy Scouts of America, the national organization, which is based in Irving, Texas, they're the national organization, and they oversee about 250 what they call local councils. So local councils are geographically spread out across the United States and in U.S. territories as well, including Guam, Puerto Rico, Virgin Islands, stuff like that. And then so about 250 local councils, and then you've got if you're at a school and you want to be in a Boy Scout troop or Boy Scout unit, where those meetings going to be held. Oftentimes it's at the local school or the church. The Latter-day Saints or the Mormon Church, they had a real symbiotic relationship with the Boy Scouts dating back for about a century until very recently, whenever that relationship was terminated. So you see a lot of the allegations that are being made against the Boy Scouts also involve Latter-day Saints. So too the Catholic Church, Methodist Church, things like that. But as we were talking last time, with the nature of pedophilia and childhood sex abuse, a large percentage of kids that are abused do not report it, or if they do tell somebody, they're not believed. And that was certainly the case. I know that society has changed quite a bit. I think we'll all agree, just over the past few years, but certainly over the past few decades. So you go back 1950s, 1960s, 1970s. Oftentimes, whenever there was an allegation of childhood sexual abuse, the child was, basically told you're lying, or you're going to hell if you say something like that, or it was just swept under the rug. Very rarely was it actually reported to the police, and even more rare was actual prosecution for that. You can see the incidence of that rising through the 50s, 60s, 70s, 80s, and stuff like that. But just like child, people are unlikely to report it, or people want to sweep it under the rug. You're even less likely to bring a civil suit against your abuser and the organizations that harbored the abuser arising out of that damage. So, as you know, the civil statute of limitations in most states may be 2 years. So, and that statute starts to run from the time of your age of majority, so 18 years old. If you're in a 2-year statute state, you have until your 20th birthday to file a civil claim for injuries arising out of childhood sexual abuse. Now, because of that, and because of the fact that a lot of studies that have been done over the past couple of decades, a lot of research has been done. It's been discovered that the median age at which a grown male will basically come out and admit that they were abused as a child was somewhere about 52 or 53 years old. Yeah. So by the time that you feel comfortable enough to tell your spouse, your family, hey, whenever I was a kid, remember that that Boy Scout troop that we were in, that Scoutmaster that everybody loved, he sexually abused me. You're like, oh. Okay, well, it's too late to criminally prosecute that person if he's even alive anymore. I mean, you're. I'm not going to guess at your age, Greg, but I'm still in my 40s. But I mean, I don't even remember what was going on when I was in 3rd and 4th grade, or any of my specific teachers. So, I mean, the odds of holding
32 is the answer. 32 is the answer. Keep going. Okay.
Yeah.
Carry on. Go ahead.
Do we have AT&T on these lines? I don't know. But so where were we? Yeah. So the childhood sexual abuse statute of limitations, 52, 53 years of age is the median age in which people come out and say, hey, or admit. And so by the time, that comes around, it's very unlikely that you're going to be able to criminally prosecute that person, depending on what jurisdiction you're in, and even less so under the prevailing civil statutes of limitation that were in every state of the union. So in recent years, in light of a lot of high profile scandals that have come to light, USA Gymnastics is a huge one, the Larry Nassar thing, Jerry Sandusky, you name it. These are high profile sexual abuse cases. And in light of that, and a lot of states, New York, California, said, hey, this is not right. You've got kids that were sexually abused, often horrifically, over a period of many years. The studies are just, it's conclusive. If you're sexually abused as a kid, you suffered grievous damages that are likely to last for your entire life and are likely to cause adverse effects, your relationships, to society. I mean, I don't even have to go into it. We all know about that. And so legislatures of some of these states thought, well, man, that's not right. We need to do something about that. Not that you can ever make anyone whole having to experience after having experienced that. But what they did was they reopened the civil statute of limitations to allow people that the statute had passed decades before, enable them to come back in and pursue justice against these organizations like the Boy Scouts of America, the Catholic Church, Baptist Church, whatever. And I'm not trying to single out any one of these institutions. I mean, we're all human beings. If it's run by human beings, there's going to be failures and stuff along the way. So I want to keep it, So, but anyway, the statute of limitations were opened up in large population states like New York and California. And so whenever that happened, you start seeing the civil claims being made against the Boy Scouts of America start to increase slowly but surely. And sure enough, that was a national trend. You had Arizona did it, North Carolina, New Jersey, and even more recently, very Republican states such as Louisiana, my home state, Arkansas, states that are you would normally think are not going to pass. If they're going to pass a tort reform measure, it's going to be limiting people's rights to hold people accountable for the damages that they caused. Not so here, and I believe the vote in Louisiana was actually unanimous. Very rarely do you have bipartisan support for anything, let alone something of substance. So, when you're seeing that national trend, the Boy Scouts, and the Boy Scouts of America filed bankruptcy in January of 2020. That was actually a year or two before Louisiana and Arkansas passed their what are called open window or revival statutes. And what those statutes do is it gives the ability, like I mentioned before, people that are 50, 60, 70, sometimes 80 years old are able to come back in and file a civil claim for the childhood sexual abuse that they suffered. Now, whether or not they're able to prove their case, okay, that's another thing. But at least they have a shot at actually obtaining some measure of justice.
All right. So when the Boy Scouts, all right, so the statute of limitations is open in these states for a certain period of time. A bunch of the Boy Scout people that were in the Boy Scouts get word they've already matured, they're living their lives, and they've already suffered. Now they have an opportunity. They file a bunch of claims against the Boy Scouts. They file for bankruptcy in 2020 because of the number of claims that are being filed against the Boy Scouts. And at
82,000.
At that point, when they file for bankruptcy, they're basically doing two things from what I understand, and you can verify at least two things. One of which is they're no longer contesting these sexual abuse claims. So while you point out that, yeah, all right, now you have a window, you can go back 40, 50 years ago, whatever, but proving it might be difficult. Well, when they file for bankruptcy, you no longer have to prove that you're still going to have to file a claim of proof, but they're effectively throwing in the towel on the overall allegation that there was widespread sexual abuse there. Number one. And number two, when you file for bankruptcy protection, you have to open up your books and show how much money you have and your insurance and all that. And that is what bankruptcy protection is about. All right, so now we're in bankruptcy. What happens next? What's the next big thing that happened leading up to this decision in SCOTUS?
Taking your question literally, COVID happened right after that.
Yeah. Okay.
So yeah, the Boy Scouts, so they filed bankruptcy, I believe, in January or February of 2020. COVID pandemic hits. Got it?
Yep.
Okay, so the Boy Scouts filed bankruptcy January, February 2020. Pandemic hits right after that. But so you have your day one briefs. When you file bankruptcy, just like any other lawsuit, it begins with a complaint. With bankruptcy, it's called a day one complaint. And really on the first page, the Boy Scouts said more or less, because of the mounting number of civil claims being leveled against them by virtue of this national trend to open up the statutes of limitation for childhood sexual abuse, they had no choice basically but to file bankruptcy. And so you file bankruptcy, ideally, in order to deal with all your creditors and liabilities and restructure things so that you can emerge, hopefully, and move forward and carry on with business without the cloud of litigation above you. And so, the Boy Scouts didn't have any really any other significant creditors that I'm aware of. They had a couple of claims, some personal injury cases at some of their camps, but by and large, it was all these sexual abuse cases. So even though the Boy Scouts of America are located in Texas, in Irving, Texas, which is within the United States Fifth Circuit Court of Appeal, and so the United States is broken up various circuits, and then obviously everybody knows the Supreme Court's on top of that. Fifth Circuit includes Texas, Louisiana, and Mississippi. So so the Boy Scouts did a curious thing. They reincorporated in Delaware, and then shortly thereafter, then filed bankruptcy. And they did that to take advantage of the fact that Delaware, which is in the U.S. Third Circuit Court of Appeals, the Third Circuit recognizes what's called non-consensual, non-debtor third-party releases, whereas the Fifth Circuit Court of Appeals does not. And that's significant because one of the few instances that the United States Supreme Court will actually hear a civil case is if you have a disagreement between the various circuits on the same issue. So you mentioned earlier Purdue Pharmaceuticals and the Sackler family. That's exactly the case here. So they filed bankruptcy in Delaware. The judge sets a deadline for all creditors to make a claim in the bankruptcy. Whenever someone's in bankruptcy, just like you have a regular statute of limitations to file a claim against somebody that injures you or for whatever civil claim that you have, Same thing with bankruptcy. The judge says you've got a deadline of, I believe it was November 16th, 2020. Everybody that has a sex abuse claim against the Boy Scouts needs to file what's called a proof of claim form before that date. And so if you think back to maybe, summer of 2020, I don't know about you, I was seeing, Boy Scout commercials all the time. Have you been injured? Stuff like that. We decided to get into that litigation, I believe in August. Kind of long story on how that happened, but I'm glad my firm didn't get involved in that. We ended up pretty heavily involved. In fact, got over 1,000 cases. But I know a number of firms were really aggressively advertising from day one. And so at the end of the day, as of November 17th, it turns out 82,200 claims or something like that were filed. So that might seem like a lot, but when you realize that the Boy Scouts of America over the last century, probably tens of millions of people, tens of millions of boys, and very recently girls participated in Boy Scouts at some point in their lives. And so 82,200 something cases filed sexual abuse claims, and that I would think is probably a fraction of the number of people that were actually abused as kids in connection with scouting activities. But anyway, that's the universe of cases there. So you also take a step back for a moment. All right, you've got childhood sex abuse cases. You're not going to resolve them in the regular tort system. Now you're in a bankruptcy system. Going back to the point that you made, yeah. So it's more of a claims process when you get to this level. I mean, you still have to provide evidence and make a prima facie case that yes, I was involved in scouting, I was abused in connection with scouting, and obviously if that happened, you suffer damages. But it wasn't limited to just the states that have an open window, or for cases that were within the statute of limitations. Basically, everybody in any state that you lived in was able to make a claim.
Yeah.
So that's all of those things go into whatever the settlement matrix is when it comes to compensating people. So after the bar date's what it's called, November 16th, then you've got a number of different competing factions of plaintiffs' attorneys that are involved trying to negotiate a settlement. And at that time, we started receiving from the Boy Scouts of America all the good stuff, all the information about their insurance over the years, access to a lot of their confidential information about what's called the perversion files. That was that secret database that they were keeping over the years of people that they believe were credibly accused of childhood sexual abuse or otherwise not fit to be around scouts and minors. So there was some back and forth. There's an official creditors. You got 82,000 claimants. You got some firms that represent several thousand. You have other firms that might represent one or two, but you can't have several thousand, plaintiffs' attorneys all, in the room. There's too many seats at the table. So what will happen, like any, large litigation like this, a judge will appoint a leadership committee. In bankruptcy, there's the official, like the tort claimants committee.
All right. Tort claims committee.
So you have the tort claimants committee, and the tort claimants committee here was generally composed of attorneys, from what I understand, had a lot of pre-petition claims pending against the Boy Scouts. And pre-petition, that simply means, before bankruptcy was filed and versus after bankruptcy was filed. So filing of a bankruptcy petition, anything before that is pre-petition. So the TCC was generally composed of attorneys that had a lot of pre-petition claims out there. And because you had the whole statute of limitations issue, most of those TCC attorneys were representing individual claimants that had good viable claims that were within the statute of limitations in the jurisdiction in which suit was filed. Whereas once you have a bankruptcy and you have something as big as the Boy Scouts of America and sexual abuse, that brings in the mass tort bar. And so in comes a number of other firms that are very well heeled. They've got good relationships with a lot of these litigation finance firms, private equity groups, hedge funds. They go and they borrow money at 22, 23% or whatever it is. I'm not familiar with that that way of doing business, but It's a big deal now, litigation finance. And so these are the firms that were typically running commercials nonstop throughout 2020 through the summer and into the fall up to the bar date deadline. And these firms, and it's most of the same firms that were also involved in the Purdue pharmaceutical bankruptcy. But a lot of those firms, and it's not many, it's maybe, I don't know, a dozen, maybe less than that, maybe about 9 or 10. But they quickly got to a point where those firms combined represent probably 70-80% of those 80,000 cases that were actually filed. And so a lot of those firms got together and they put together what's called an ad hoc committee, but it's basically called the coalition. So coalition firms have a different business model than a lot of the firms that were on the TCC, and indeed a lot of the other firms that represented former scouts that were abused. And so think about it. If you've got a large loan at 20-something% interest, and you want to pay that thing back as soon as possible. So basically, a lot of the considerations that would go into the negotiating factors for the coalition firms versus the TCC firms, that might differ. Just a different way, different business model, different way of going about doing things. But at one point, that coalition of firms that I just mentioned, they sort of took over the negotiations. They had the majority of cases, and they were, I guess, leading the charge. And they were, giving updates to everybody. Everybody at the end of the day, working together towards a common goal. How we get there and what that common goal looks like, well, that beauty's in the eye of the beholder, I guess, something along those lines. But during that time, we were getting a lot of the insurance information back, and I was just shocked. The Boy Scouts of America, one thing that they did do is they had an enormous amount of insurance coverage. 50s, 60s, 70s through the 80s, there was no aggregate limit on a lot of those insurance policies. And what an aggregate limit is for your viewers, just about every business, you got to have insurance. If you're a homeowner for your car, it's law in every state, but it's prudent that you have business insurance coverage. So you'll have a comprehensive business liability policy or CGL policy, and then there'll be a limit of insurance. And it's usually, on a per occurrence basis, and then there's an aggregate limit. So, for example, if you're in 2 wrecks, using the auto insurance example, say you have, $100,000 is your limit, but it's $50,000 per occurrence, and then with an aggregate limit of $100,000 a year. So you can be in 3 auto accidents, and the limit on each accident is $50,000, but in any one year, the total amount that the insurance will be liable to pay is $100,000, no matter how many wrecks you get into or what your liability is. Well, with the Boy Scouts, a lot of these policies didn't have an aggregate limit. So you might have $500,000 per occurrence, but there was no limit to the number of occurrences that the insurance company was liable to pay. And that's really important because most instances of childhood sexual abuse, at least with our clients, it's very, very rare. Rarely is it just an isolated event. I mean, sometimes it is, but in most of your egregious cases, it follows the same sort of script. There's an initial stage where the abuser starts, befriending the kid, basically making sure that he's a good victim, I would imagine, and then grooming him, and then it escalates over a period of time. And so in the insurance context, each instance of abuse is its own occurrence. So if you have someone that's abused over a period of years, that's going to be dozens of occurrences. And if the per occurrence limit is just $500,000, well, each one of those is 500,000, 1 million, 1.5, and so on. And then on top of all that, you also have punitive damages, which all these policies generally cover. So when you're looking at it like that, you've got pretty much unlimited coverage, because when you talk about childhood sex abuse cases, these don't go to the jury very often, because defense attorneys and defendants know more often than not, you're going to be found liable, and those damages are going to be pretty high. And it doesn't matter what jurisdiction you're in, whether you're Democrat, Republican, conservative, libertarian, atheist, it doesn't matter. 12 men and women anywhere in the country can all agree on a couple of things. One of them is childhood sex abuse is wrong, if you're a victim of it, you've been seriously injured, and that is a type of conduct that needs to be punished and deterred, which is the standard for punitive damages in every jurisdiction that I know about. So that's why you get these massive jury verdicts. There was, to give you an example, there was the only Boy Scout case that I'm aware of in the past couple of years that's actually gone to trial. It was in New York. I believe it was 2022, and it was a former scout who was in his 60s who was abused by his scoutmaster whenever he was 12. And that case, he was awarded $25 million.
Wow.
There was another case more recently, I believe it was against LDS, the Mormon Church, and it was on behalf of a young lady, and she was awarded over $1 billion.
Oh my God. Wow.
Yeah, it's so when you start talking about, the damages here, and you got 82,000. By the way, 82,000 is a lot, as we mentioned before. It's probably a fraction of the people that were actually abused, and even within that 82,000, like any other large settlement program or any large tort, you're going to have some people that initially claimed that they were abused, and then maybe they weren't. I don't know, but be that as it may, but that's why you have a standard of proof that even though it's a settlement program, you need to produce objective evidence that you were in scouting, the abuse occurred in relation to scouting, and that you were damaged, and that then you have the other factors, statute of limitations, the extent and magnitude of the the harm and things like that.
All right. So you got an enormous pile of money that can be used to compensate the 82,000 that had filed claims. You have a group of law firms that are representing the bulk of these claimants, these Boy Scouts. A lot of these large players, as we would like to call them, or as I will call them, in part were funded with litigation financing at 22%. And their motivation, obviously, is to not only get compensation for their clients, but to get it quickly so that the 22% doesn't, completely overwhelm whatever they're going to get as attorney's fees. So what happens? They settle? Is there a settlement? Where do we go?
Yeah, so there were a number of different iterations of the what's called the plan of reorganization. Whenever bankruptcy is filed, and I don't know about you, Greg, but I'm relatively new to this whole bankruptcy thing, and it was certainly an eye-opening experience. The bankruptcy courts, it's federal, but your bankruptcy judges are not Article III judges like every other federal judge, where they're appointed by the president, confirmed by the Senate for life, say high crimes and misdemeanors. Although the first level of appeal from the bankruptcy court is the district court, which would normally be the trial court in any other federal civil case. But yeah, so in bankruptcy, what you'll do is you'll have what's called a plan of reorganization, and that's a plan that says, okay, these are the assets that we have, these are all the creditor classes, and this is how we propose to get these people paid, and this is where the money's going to come from, and that's boiled down into a nutshell. And then you've got different classes of creditors, and bankruptcy is a really bizarre thing in that you could have people that are just completely opposed to each other, or classes of creditors that are opposed to each other, and then that night there's a meeting that takes place, or some call at 2 a.m. and then the next day at court they're buddy. Allegiances change, and there's a lot of horse trading that goes on behind closed doors. But with the Boy Scouts, there were a number of plans. I believe the one that was ultimately approved was so before we got cut off.
The one that was approved.
Yeah, so the one that was approved, I believe, in around September of 2022. So the bankruptcy was filed in January of 2020. September of 22, so with 2.5 years or something like that, and nearly 2 years after the bar date. Yeah, there was a lot of going back and forth, but when you're talking about the insurance situation, you're trying to get as much money as possible into a pot from which to pay 82,000 claimants, and within those 82,000, you have to determine, okay, which claimants were more injured than others, which ones suffered a type of abuse that is worth more money. You need to account for whether or not the case is within the civil statute of limitations. What do you do with certain states that might there's certain litigation on the books, but it hasn't been passed yet. All these different considerations, but by far the biggest one is how much money are you going to put in that pot to be split up between everybody else? Well, when we're talking about the insurance situation with the Boy Scouts, this is very important. You don't only have just the Boy Scouts of America, you have all of the local councils as well. And at some point, I believe it was around 1979, around 1980, the Boy Scouts entered a different insurance regime. They started getting insurance to where all the local councils were actually additional insureds underneath the Boy Scouts umbrella. And that was in addition to whatever insurance those local councils also got in their own right. So you've got, layers upon layers of insurance, not just at the local council level, but at the Boy Scouts of America level. And then you have excess coverage over that. We're talking hundreds and hundreds of different insurance companies over the last century. Really, it's basically a century of stuff. I believe some of the firms that were hired to go through this, it was such a big ordeal. You had to get other experts to come in and do this, and they don't even call themselves insurance attorneys. They call themselves insurance archaeologists, like Indiana Jones and such.
Yeah,
maybe esoteric thought, but anywho, at one point, a lot of the stuff was being added up. A lot of these policies are not digitized. You're having to go back through. I can't imagine the dust in some of these rooms that these guys had to go through, but anyway, every week we were getting reports on, how much coverage was available and just generally the nature of it. And I stopped counting at, I think it was like 120 billion, so you're hearing that as a plaintiff's attorney, and you've got all these people that are clearly injured. These are all large cases, from a damages standpoint, monetary standpoint. The biggest question as a plaintiff is there going to be money to pay it? You certainly have liability there. And I believe the Boy Scouts all but admitted that. So you got a lot of insurance. So you would think, all right, let's just go and, we're going to have a probably $15-20 billion pot of money to make sure that these, the people that can adequately prove their cases receive what is, fair and just compensation, or which we would call made whole, which, like a wrongful death case, you're never really made whole after something like that, but to the closest you can approximate it with a dollar amount. But, these insurance companies, they're not stupid either. And they like to hold on to their money, as everybody knows. They love to take your premiums, but when it comes time to pay, So I don't know what went on behind some of these closed doors, but I remember at some point there was, among the insurance companies, you've got Hartford, Chubb, AIG. If there's a large commercial carrier, there was a policy somewhere that covered the Boy Scouts. So one of the strategies was, let's pick off some of these bigger insurance companies and see what we can get from them, because those insurance companies are looking at that. That's not if you're an insurance executive and all of a sudden you've got these claims that you're on the hook for that are decades ago, and all of a sudden these states start passing revival statutes, opening up the statute of limitations for cases that if they go to a jury, more often than not, it's not a small jury verdict, it's a big one. And so these insurance companies, they start playing hardball. They don't want to settle. I think they probably knew better than anybody that a lot of these firms that have 8,000, 10,000 cases, they have that many cases because, maybe they borrowed the money for that and there's interest rolling on it. So when you have that dynamic, that changes, the leverage that you have in civil litigation of, okay, we've got these cases. If you're on the plaintiff side, you're talking to the defense and the insurance industry. Okay, if you don't want to settle, well, we're just going to take these cases to trial one by one and keep getting jury verdicts until you can't stand it anymore. And then the board of directors either replaces you or just basically there's a massive coup and they all come to the table, please take our money and let's get out of this. Yeah. Well, it doesn't work whenever it's basically the roles are reversed a lot of times when you think about it. But anyway, at some point, the Boy Scouts do have to, exit bankruptcy, and the court's going to, force you along, get something done. I believe in bankruptcy, the debtor has the first shot to present a plan of reorganization. And if that doesn't work, the court will allow certain classes of creditors to come up with their own plan and see if that passes. So obviously, if you're the debtor, you want to have a hand in that plan of reorganization. You hear me?
All right.
So we were talking about the insurance situation. So one of the first insurance companies to make a deal was Hartford. Hartford was on the hook for a large amount of money. I thought personally that we should be getting a couple $2 billion out of them. But I guess that was overruled. There was a deal that was in place for, I believe, $787 million with Hartford. That was the first domino to fall. And then after that, negotiations took place with Chubb. That was the other major, one of the other major carriers that had extensive liability. And I believe the deal with Chubb was for about $800 million. And when you had that situation, it was interesting because under the terms of that deal, assuming that the plan is blessed and consummated, it basically, the insurance company buys back all the insurance policies that are out there. So there's no lingering issues of coverage. So it's like, here, we'll give you $800 million, buy back the policies. That's it. So then also the local councils came in, they kicked in a couple $100 million. I know there was a lot of infighting between the local councils, some of whom didn't have any claims made against them. And so if you're the local council, you're thinking, well, why should we pitch in? We didn't have any, we don't have any liability, but anyway, something was done behind closed doors. It was crammed down or whatever, but the Boy Scouts of America and the local councils collectively agreed to put in about $600 million of money and property. That also pays out over a number of years too, from what I understand, like maybe like another decade or something like that. And I know some of that, some of those assets need to be sold and reduced to money and put into the pot. So the plan that was ultimately consummated and agreed to by the district court, by the bankruptcy court, and approved by the district court, was about a little shy of $2.5 billion, which, in my opinion, is not nearly enough to pay for everybody, but that's what it is. So,
all right. So let's take a time out. All right. So the local chapters are where a lot of the sexual abuse did take place.
Yeah.
So they have liability.
Yeah. I mean, so the local councils, they're not debtors, but they were arguably in the best position to prevent and, mitigate. They were the boots on the ground, They were the people that had the eyes on. They were screening the people. They were selecting, hey, you could be the scoutmaster. They were the people, whenever somebody reported, hey, my scoutmaster did something inappropriate, they're not going to the Boy Scouts, they're going to the local councils.
Yeah. All right. So the local councils, they kick in some money, but they don't file for bankruptcy protection themselves. So they don't have to show, what their assets were. Now we're in the settlement, and the settlement is basically a little less than $2.5 billion. And as part of that plan in the bankruptcy world, the Boy Scouts of America, if the settlement is approved and they pay it all out, they will come out and they will no longer be responsible legally for any of the sexual abuse.
So part of the plan created, so the plan will have an injunction and it'll funnel all of the sexual abuse cases to a separate entity, which is a trust that's going to be overseen by a former federal judge, Judge Hauser. And she's going to be the trustee. And then she goes through, she promulgates a questionnaire. All the stuff is put together as part of the plan of reorganization. Let me backtrack for a second. The plan of reorganization has a number of different provisions in it for all the different creditors and all that other stuff. But the cornerstone of that plan is what's called the trust distribution procedures for abuse claims, or AKA the TDP. And the TDP sets forth all the criteria that you need to establish in order to qualify for compensation and how much compensation that you're going to get. So
right. I want to talk about the local councils, though, in terms of the plan of reorganization and the bankruptcy and the Boy Scouts making the payment. They got some contributions from the local council. The local council, are they going to get that same bankruptcy protection where they are now off the hook?
They do. They're going to be a protected party. 100% off the hook
for the future. They don't have any legal responsibility if this plan goes into effect and is finalized, yet they did not have to file for bankruptcy protection.
That's correct. And it's not just the local councils. It's all the churches. It's all the sponsoring and chartered organizations. I believe I read somewhere, it's over 100,000 sponsoring and chartering organizations. So, it's not very hard apparently to become, to get affiliated with the Boy Scouts of America. And obviously, you want to make it easy for people to join your organization. But, there's a lot of questionable people that were able to, over the years, to go and, submit whatever paperwork was necessary to get their own Boy Scouts unit and basically run it as they see fit. So
all these groups are basically, I want to get back to the legal issue. They are the non-consensual parties that are getting released from the litigation. And that is the issue that's up at the Supreme Court, is whether you can have a plan that through bankruptcy enables these parties to get off the hook, presumably on the cheap.
Yes. And that's certainly, in my opinion, the case here. The one notable exception that the bankruptcy judge disallowed was Latter-day Saints. Like I mentioned earlier, Latter-day Saints had a symbiotic relationship with Boy Scouts dating back a century.
Yeah.
All my Mormon friends would tell me, anytime they had any sort of extracurricular activity or anything with the church, it was always involving the Boy Scouts as well. So I know with our cases, I think we've got about 1,300 Boy Scout cases. A significant percent, not most, but a sizable double-digit percentage of our cases involve the Mormon Church or Latter-day Saints. So Latter-day Saints, I gave you the example earlier of the one case that's gone to trial recently, $25 million. Well, if let's just say 10% of all the sexual abuse cases were affiliated with Latter-day Saints and the Mormon Church. So that's 8,000 something cases. Well, multiply 8,000 by 25 million. And I'm not saying they're all that quality.
Obviously the legal exposure,
but even a fraction of that. And so, but they were going to get off their contribution was going to be $250 million. That is absolutely absurd. And they were going to get complete protection. You can't sue them again.
Yeah. All right. So now the plan goes in front of the bankruptcy judge. The bankruptcy judge sets up some type of process to see whether the Boy Scouts actually want to agree to it.
They put it to a vote.
They put it to a vote, and 75% of the voting Boy Scouts.
Not the first time. So the first time around, they fell short. I believe the threshold is 75%. Which look, if you're one of the minority people, this is the thing about bankruptcy. Okay, that I learned, and it's very troubling. If you're the part of the TCC that I mentioned before, the Tort Claimants Committee, and you had a bunch of pre-petition cases, which you presumably screened, these are solid cases, so much so that you're going to file a lawsuit, standalone lawsuit for these cases. Well, when you look at the 82,000, that's only, that might be 1,000 cases, or not even that much. All those people could vote no, and it's still going to be 90 something percent. Are going to vote yes, and then you're overruled, and then your $10 million case goes to $50,000. That's difficult to accept if you're one of those injured claimants or the attorneys representing them. Speeding up again, the first vote that was put out there, they didn't get the 75%. And I like to think that my firm and a couple others made the difference because it was close. It was like 74 point something percent. And then at that point, some more negotiations were done. I believe the coalition and the TCC got together. I was in trial at the time on an unrelated matter, but there were some concessions that were made, which allowed people that have some of these very strong standalone cases where, for example, if you were abused by, say, your scoutmaster who was also an elder in LDS or a priest, and you're in an open window state, and then when that person was reported, arrested, tried, and convicted of abusing your client as well as many other people, well, then at that point, the civil suit is the only issue there is just how much are you going to pay them. It's an issue of damages. I mean, the conviction is preclusive on the issue of liability. I mean, you still have to show the association with scouting and stuff like that, but by and large, it's just an issue of damages at that point. So those were the people that had the biggest. Certainly, I had the biggest issue with. What are we going to do with these cases? Because it's not fair to these people who were clearly injured to have to take a deal that's going to pay them, pennies on the dollar and make their case basically equivalent to one that's, just say not as strong. So there were some provisions put into the plan to address those issues. One of them was, I believe there's an independent review option where you went to basically a neutral that was overseen by Judge Hauser, but you had to pay $20,000 in order to take advantage of that. That's a more exacting level of review, but it's more like arbitration. And, there's a lot of question marks on how that's going to be done and where the money's going to come to pay for it. I believe, you can go through that route and you can basically get awarded what would approximate what you could expect to get for that type of case in the tort system. And then you would able to, the money to pay for that would come from some of these insurance companies that didn't settle. This is one thing, a point I didn't make. Some of the major insurance companies, Hartford, Chubb, they settled, but hundreds of other insurers did not. So there's a large number of insurance policies out there that are still on the hook. So a lot of this is kind of, remains to be seen what's going to happen. And again, there's this cloud hanging over with the Purdue Pharmaceutical deal, which I know we'll get to in a second. But there is a third option that you can do. Well, one of them is a quick pay option, which is $3,500. And basically, you just need to sign your name on it and you get that money. The only people that we have that did the $3,500 quick pay option were people that basically passed away shortly after they retained us. But apparently there was something like 8,000 of the 82,000 claimants went with the quick pay option. Some of them say they accidentally did it. I don't know. I know the bankruptcy judge a week or two ago overruled some of the objections. I know a group of those people that ostensibly selected quick pay tried to say that they did so by accident, whatever. But so that you have the quick pay, and then you have the independent review option that I just mentioned, where you have to pay basically $20,000. And then you've got what's called the claims matrix claim. Those are by far the vast majority of those 82,000 claimants that are going to make a claim have to go through what's called the matrix claim. And the TDP outlines what you need to establish. You need to establish proof of connection, proof that you were in scouting, proof that you were abused, and proof that your abuser and your abuse was in connection to scouting. You can't have a situation where, you were in the Boy Scouts and then after that, something unrelated to Boy Scout. Basically, you were abused unrelated to scouting stuff. You need to prove that little connection. And then you've got the tiers of abuse, which is important here. I didn't have a problem with the tiers. I don't know how they broke that down. So the worst tier of abuse, use your imagination on that. But, if you have anal penetration with,
8-year-old.
Awful, terrible stuff. The base compensation there starts, I believe, at $600,000, and you can get up to $2.7 million. There's tier 2, which is just below that. That's I think $450,000 to 2 point something million, and it goes all the way down. So I didn't have a real problem with that. But again, it goes to where are you going to get the money to fund those? Because currently, what's in that trust or what should be in the trust, close to 2.5, that's not enough. That's not nearly enough. But
Okay. All right. So the bankruptcy judge approves the plan of reorganization and it gets challenged. Where are we with this? The plan is in effect, from what I understand, even though it's sort of being challenged, or it is being challenged by some of the groups.
You have two groups of claimants, and you've got one group out of Guam. I believe they're called the Lujan claimants. It's about, 75 people that were abused in connection with scouting activities from, I believe, 1955 through maybe 1981 or something like that. So again, this goes back. Those are, you would imagine, very good cases, all of them, 75. And then you have another group of claimants that are represented by a firm up in, I believe, Oregon or Washington State. That's another 50 or 60 claimants right there. So those claimants are arguing that they should have the ability to sue these non-debtor protected parties like the local councils, the church, schools, or whoever was involved in those separate instances of abuse. They should be able to sue those claimants in open court because the statute of limitations is open where they're at, and they shouldn't be bound by the bankruptcy deal that's being basically shoved down their throat.
Yeah,
and so they're appealing it on that basis. I mean, essentially, the argument is, in a nutshell, you have a cause of action, you've been injured. That, constitutionally, that is a property right. And by giving these non-debtors the ability to come in and put pennies or sometimes absolutely nothing into the pot and give them a release, basically making them get off scot-free, that's infringing upon those claimants' constitutional rights. So that's it in a nutshell. And it's the same issue that's involved in the Purdue Pharmaceutical case. As everybody knows, we've got an opioid epidemic going on right now, and opioids have always been addictive, but we didn't have a pandemic basically until the Sacklers invented and started pushing OxyContin. And at this point, it's in the hundreds of thousands of people die in this country every year. I don't know what the numbers are, but it's just staggering, absolutely staggering. And you've had litigation over this for, I believe, a decade now. There's no dispute that the Sackler family was involved. They knew what was going on, and they continued to do it. They did so because they were making an astounding amount of money in the process. And not only did they know that, they fully knew that people were going to come after them at some point, because there is no other way to explain why they had the ownership structure that they did, and why their assets are in places like the Faroe Islands and Jersey, and not New Jersey either, but places that basically you can't. It's very difficult, if not impossible, to get to much of their assets. But so the Sacklers are not in bankruptcy. Purdue Pharmaceuticals in bankruptcy, and in that case, there were a number of settlements being made with the various states that sued a lot of these opioid entities for the damage that occurred in their state as a result of the opioid epidemic. You have the increased cost of healthcare to treat these people, the increased cost to jail these people, all the different social, the negative social effects that come from having basically a drug epidemic. And so Purdue was able to settle with a number of those states. Some of the states objected to that. The Sacklers came in. By the way, the Sacklers were in there saying, I think, $3.5 or $4 billion that the Sacklers were going to pitch into the deal, which is, pennies compared to what the Sacklers made off of this. And then, so after the objections happened, the Sacklers kicked in another $1 billion or $2 billion, and then all the objectors went away. So, as you know, Greg, as an attorney, courts can only rule on the issues that are brought before. So, if you're able to get all of your opponents, make them happy, they're not going to appeal it, and if the courts, if the issue is not appealed, a reviewing court has nothing to do. There's no jurisdiction to do that. Well, to prevent stuff like that, the United States Department of Justice has what's called the bankruptcy, the U.S. trustee. So in Purdue Pharmaceuticals, the trustee chimed in, said, okay, even though everybody, you have no more objectors, we have a big problem with this, because we calculate that the Sacklers' civil liability is somewhere in the and the numbers just crazy. It's like $17 trillion, which makes sense, because you multiply 100,000 people a year dying off this times 20 years or whatever the numbers are, a couple $1 million. Yeah, pretty much that's how you get there. And and the Sacklers' liability is, you're talking about people that are dying over this. Your son, your father, your mother, whatever. It's been a scourge. It's absolutely awful. Some of the saddest, worst stories I can think of. And there's not a single person that's going to see this podcast or hear it that doesn't know somebody or some family that has been devastated by opioid epidemic.
Yeah. Okay. Hold on. Take a breath. All right. So we got this Purdue. Why are we talking? Purdue Pharmaceutical is the company that the Sacklers company. So Purdue's getting sued, and for the opioid crisis, they file for bankruptcy protection, just like the Boy Scouts did. They end up with a plan of reorganization, which consists of Purdue basically saying, here's all the money that Purdue Pharma has, and the Sacklers are going to kick in $3, $4, $5, $6 billion. And part of that plan is that even though the Sacklers didn't file for bankruptcy, they're going to get the bankruptcy protection.
They get the release.
That plan goes into effect. Everybody gets paid out. The Sacklers are off the hook for $6 billion, even though they caused whatever $10 trillion worth of damages to the country and people and all that. But
they get away with only paying for 6, and then even equally important, if not more, is the fact that they get to sleep just well at night, knowing that they don't have to worry about this massive litigation that's going to chase them for the rest of their lives.
So
And don't
they
forget,
are
the
the
first plan, yeah, the first deal was going to be that they were immune from criminal and civil liability.
yeah.
As you know, it's
Yeah.
very, very hard to criminally hold these people liable. It's just, the nature of our system here in the United States.
Yeah.
But that's why you have the civil justice system, and that's
So
the one that we really have to worry about.
So the Sacklers are the non-consensual parties
Yes.
that are going to get the bankruptcy protection in the same, similarly or exactly, the local councils for the Boy Scouts. So you got the Boy Scouts and Purdue Pharma, and then you have the local councils and the Sacklers all getting off the hook. And the Supreme Court is going to decide whether the bankruptcy court has the power to give these kind of releases to parties that don't actually go and file for bankruptcy and open up their books, but they're going to get the bankruptcy protection. So that's where these two cases are intersecting, and SCOTUS is determining the issue. Justice Alito, what does Justice Alito do?
So, if you look at the procedural history of these cases, in Purdue Pharmaceuticals, which started proceeding a few years before the Boy Scouts, you have the plan, the bankruptcy court approves it. In that case, the district court actually reversed it, says no, federal courts don't have the authority granted to it by the Congress to approve these non-consensual, non-debtor third-party releases. Now, the Second Circuit overruled the district court, re-implemented the plan. That plan was about to go into effect, what's called the effective date. Okay, that settlement was money was about to start changing hands, and then the U.S. trustee stepped in, filed an emergency writ to the U.S. Supreme Court to try and stay the mandate. The mandate is whenever a court makes a ruling, it doesn't go into effect just immediately. What's called a mandate has to issue, and boom, once that issues, then you can execute on it. People have to act in conformance. Whatever was ruled upon goes into effect. So in Purdue, interestingly enough, the trustee filed that motion for a temporary injunction to stay that. The court granted it immediately, and basically granted cert. As you know, there's probably 50 or 60,000 cert petitions to the Supreme Court each year. They might grant 100, so it's very rare. They only take extraordinary cases of monumental importance or that involve issues of great importance. So for them to do that like they did in Purdue was a big thing. So that happened last year, right around the time, and that was after the Boy Scout settlement was approved by the bankruptcy court. I believe it was March 2023, the district court approved the Boy Scout settlement. And under the terms of the Boy Scout settlement, the effective date is triggered whenever the district court approves the plan. So even though you've got people that, like these two groups of claimants that we talked about, the Lujan claimants and I believe the Dumas claimants, they're appealing it to the U.S. Third Circuit Court of Appeals. It's going to go into effect. Now, that's important because you have a doctrine what's called equitable mootness. Equitable mootness comes in where you have a plan, it's in place, money starts changing hands, the settlement is starting to be consummated, and then and it comes into place here with Boy Scouts, potentially, because you've got Purdue Pharmaceutical up on appeal to the United States Supreme Court. And if the Supreme Court rules, as many people suspect they will, ruling that the non-consensual, non-debtor third-party releases are just not proper, then it would apply to the Boy Scouts. However, there's a doctrine called equitable mootness. If the Boy Scouts plan is already, underway, money's being paid out to a lot of these claimants, it's hard to basically, the horse is out of the barn. You can't put it back in. The genie's out of the bottle. So that's the equitable mootness doctrine.
Yeah.
And the Boy Scouts, in fact, filed a motion, an amicus brief, in the Purdue Supreme Court case, saying, although they agree that they believe the plan is proper as is, and the non-consensual, non-debtor third-party releases are proper, even if the court should rule that they're not in the Purdue Pharmaceutical case, that case should not be applied to the Boy Scouts under the doctrine of equitable mootness.
All right, because they've already started to pay out the quick pays, and there's been other parts of the settlement that have gone into effect. All right, so let's get back to Justice Alito. What did Justice Alito do in the Boy Scout case?
So Purdue Pharmaceutical oral arguments in that case were held in December. We expect a decision to be rendered before the end of the Supreme Court's term, I believe, in June. So May or June, about the time it comes out. So these groups of objectors that we talked about, they're appealing the Boy Scouts plan to the Third Circuit. They file an emergency stay to the Supreme Court because that independent review option that we discussed earlier, where you have to pay the $20,000, the deadline to elect that independent review option was put at February 16th by the trustee. So last Friday was the deadline to make that election and pay the initial $10,000.
Yeah.
The objectors filed saying, hey, if this deadline comes and goes, we're going to be basically penalized from it. And it's going to make it a lot harder for us to prevail, even if this court should rule that the way that we think you are, Purdue Pharmaceutical, again, overruling those releases. So they file this motion. Justice Alito is the Supreme Court justice for the U.S. Third Circuit. So every justice is assigned to one of the circuits. So when you have these emergency writs, it goes to that judge, and then the judge can take it, go to the rest of the court. Hey, how you want to rule? So Justice Alito unilaterally granted the stay. It was a temporary stay to allow the full Supreme Court to consider the issue. Well, over the next week, the Supreme Court considered the issue, and they determined, we're not going to stay this. So it was yesterday, the full court came in, said, no, they overruled it. They dissolved the stay. So now the Boy Scout settlement is back on for now.
Yeah. Okay. So this is the major issue from my perspective. The issue is still alive. The Supreme Court could effectively undo the Boy Scouts settlement, even though it's in effect, and a lot of the Boy Scouts have already gotten their $3,500, and this option is in effect. So what do you, if in fact they, basically the Supreme Court says non-consensual releases in the bankruptcy world do not fly. Both of these settlements are knocked out. We don't care that people got paid. You guys figure out how to undo it. What do you see happening in that situation?
A little bit of chaos, but I think overall it'll be good. A lot of these people, I understand, they were abused decades ago. They want to see this money before they die, but that's just how this goes sometimes. I mean, justice, to get the greatest measure of justice for the most people, not just in Boy Scouts or opioid, but in other cases, this issue needs to be nailed down and ironed out, because you're starting to see every time now a company is facing, massive liabilities for whatever awful, wrongful, knowing, intentional conduct that they engaged in, and it's always in order to make more money. Okay, they're using the bankruptcy system to try and basically get out of paying a lot of money for just pennies. You're seeing it right now with Johnson & Johnson in the talc litigation. You've seen some failed attempts with the 3M combat earplug stuff, and a host of others. I mean, it's the new thing. There's some other ancillary issues there, called the Texas two-step, where you can basically take a company, create a second company, put all your liabilities into that one, and then put that deal in bankruptcy. And then the other company just goes scot-free. So it's another way to go about gaming the system. But I mean, it all comes down to gaming the bankruptcy system, and something definitely needs to be done about it, because, the way that our American system works, you've got the civil justice system there, which isn't in these other countries. It's unique to us, and you're basically destroying it by allowing companies to come in and use bankruptcy to get rid of. You're destroying people's right to hold other companies accountable for destroying their lives and hurting them and their loved ones. When you don't have recourse, I mean, that eats at the fabric of our society.
All right, so I want to end this on this last question. And circling back to the statute of limitations that was reopened, there was only a 2-year window, a period of time that people could file claims. That period of time, or 1 year, and then the bankruptcy court gave a deadline. That's all passed. So if in fact the Supreme Court says, we're reopening the proceedings, those statute of limitations have passed. So people can no longer, they can, but they're too late to file new cases against the local council. Or are they, or is it not?
Well, that's a good point that you make. So the statute of limitations are on a state by state basis, and they're not all the same. The Boy Scouts, so the bar date was in November 2020. At the time, you had the civil statute or the open window statute was available in California, Arizona, New York, a couple of these other ones. So if you have a Boy Scout case, and sometimes it was only the local council and Boy Scout involved. A lot of other times, though, you had some of these other protected parties, such as churches, schools, or whatever. It's all fact specific. Well, you got the Boy Scouts of America. You filed your proof of claim against them in a timely manner, but you also need to file suit against these other parties, just in case that this something like Purdue comes along and they overrule the whole third party deal. Well, then now those people are not going to be protected anymore, and you need to preserve your rights. So, and I know the window in Arizona, I believe, closed at the end of 2020. We filed state court suits for all of our Arizona cases at the time, and we did that for every other state: North Carolina, New York, New Jersey, California closed, I believe, last year. And yeah, it took a lot of money to file individual cases, and it's a pain, but that's just lawyering. From what I understand, a large number of other firms maybe didn't do that. And again, I don't know what kind of cases they have or what they represent. I just know that with our cases, we had a large number of them that were within the statute of limitations, and we wanted to preserve those rights for those claimants because you never know what's going to happen down the line. Unfortunately, we did.
All right,
but that window is closed. You cannot go back and file suit, which is unfortunate because
I think that is going to factor in how the Supreme Court deals with the Boy Scouts. They might make a ruling that the non-consensual releases are garbage and they're no longer, in effect, despite the fact that some of the circuit courts of appeal say yes, some of them say no. I think that, my personal take is that they're going to end up signing off on the Boy Scouts agreement. But listen, we could talk. There's so many topics that you've raised here about the problems with litigation financing, the Sacklers, the criminal release, the civil release, non-consensual parties, the bankruptcy court. We could go on and on, but we're going to have to put an